Ayan, so continuing with our topic, we've completed obligations of the vendor, and now we'll proceed to the obligations of the vendee. So even without glancing at these provisions, if we go back to the first article that we discussed here under sales, di ba? Kung babalikan natin, we said that the obligation of the buyer is to accept delivery and to, of course, to pay the purchase price. And that is what is primarily echoed under the obligations of the vendee. Okay? So we'll proceed with Article 1582. Okay? When we read Article 1582, it says, the vendee is bound to accept delivery and to pay the price. So, from the opening phrases of the first sentence or the first paragraph of Article 1582, you can already decode that one of the obligations of the buyer or the vendee is to accept delivery and to pay the purchase price or the price of the thing sold at the time and place stipulated in the contract. So, hindi lang tayo nag-i-stick sa obligation to accept and pay the purchase price, but to also do both things at the time and place stipulated in the contract. Okay? So let's say, for example, the delivery is stated to be inside the campus of University of St. Louis to Tuguegarao at 2 o'clock in the afternoon of May 20, 2022. O yan, time and place of delivery. If there is stipulated in the contract. What if there is no stipulation in the contract? If there is no stipulation in the contract at the time and place of the delivery of the thing sold. So, at the time and place of the delivery. Okay, of course, kapag na-deliver na sa'yo yung gamit, the tendency is or the normal thing to do is the buyer accepts the delivery. So, check mo na yung isa. Kasi syempre, dineliver na sa'yo. Of course, you are going to accept it. And if everything is improper, you are to pay the purchase price. Okay? Very, very common sense that is put in the civil code. Okay, to protect the rights of both parties, the vendor and the vendee. So, we will not only stick with these two, but when we say payment of purchase price, hindi yung ang ibabayad mo is check. Okay? Check. Why? Because check is not considered as, is check considered as legal tender? Under negotiable instruments law, check is considered as having the same liquidity as that of a cash. Okay, but not all times kasi. Kaya they are not considered as legal tender. So when the vendor delivers the thing sold, you are to pay the purchase price. When we say we pay the purchase price in a legal tender. Okay, yung acceptable na money, hindi basta-basta pay. Okay? Paano kung, gaya nito, sa example natin dito, Philippines to bakit dollar? Parang ganun ba? It's not a legal tender here kasi hindi naman yung currency dito. But, take note, we are in the civil code, and when we say civil code, we are going to put importance to whether the parties agree or not. So, whether if dollars pa yung binayad or check pa itong binayad, if both the buyer and the seller agree na dollars or check yung bayad, that is okay under the civil code. Why? Because the agreements of both the parties are the laws between themselves. It will bind them. Okay? Ang di lang naman pwede dyan is if it is contrary to law, to customs, to morals, public policy. Diyan lang naman nagiging hindi pwede ang stipulations or agreements. But nonetheless, generally, pwede siya as long as hindi siya contrary to what I've stated earlier. So, generally, dapat yung payment mo is in legal tender. Okay? Hindi basta-basta pay. Okay? So, we have to elaborate and focus on that one. Okay? Article 1583, unless otherwise agreed, the buyer of goods is not bound to accept delivery thereof by installments. Ito, maganda ang pagka-construct nung provision. Why? Because it lays down the general rule. General rule and then the exception. So when we read it, generally, the buyer of goods is not bound to accept delivery thereof by installments, except otherwise agreed. So, kung papansin nyo, except otherwise agreed. So, kung pinag-usapan nila na yung delivery is by installments, pwede. Okay? But generally, delivery by installments is not, okay, take note, is not allowed. Generally, hindi allowed dyan. Why? Because generally, the performance of the contract cannot be divided. Hindi divisible ang performance ng contract. Okay? Unless both parties have agreed thereto. Diba? If per delivery mo, may per bayad, pwede. If both parties agreed. But generally, delivery by installment is not allowed. Okay? So, yun yung sa Article 1583. Okay? The reasoning there is because the performance of the contract is not divisible. Okay? That's the general assumption of law. Hindi divisible ang performance ng contract. Okay? Especially if it is delivery. Okay? Pumili ka ng kabayo, diba? Alangan de-deliver sa yung per parts ng kabayo. Generally speaking, of course naman, not being hindi naman sa OA or ano, pero generally as a whole ang delivery. Okay, and it is advantage to the seller. It has advantage to the seller and to the buyer din naman if lump sum or as one yung delivery. Okay? We go to the second paragraph where there is a contract of sale of goods to be delivered by stated installments. So, there is an agreement that delivery is by installments, which are to be separately paid for. So, there is delivery by installments. There's also a payment per delivery. Okay, and the seller makes defective deliveries in respect of one or more installments, or the buyer neglects or refuses without just cause to take delivery of or pay for one or more installments. It depends in each case on terms of the contract and the circumstances of the case, whether the breach of contract is so material as to justify the injured party in refusing to proceed further and suing for damages for breach of the entire contract. Okay? Or whether the breach is severable, giving rise to a claim for compensation, but not a right to treat the whole contract as broken. So, what does the second paragraph of Article 1583 means? Okay? In summation, when there is an agreed delivery by installments and payment is made per delivery thereof, if daw merong defective delivery, if meron daw yung una defective delivery, if the buyer neglects or refuses without just cause to accept delivery, or the buyer refuses to pay one or more installments, okay, the matter can be treated as material, meaning breach of the entire contract, take note, or severable, meaning the breach is not the entire contract because the breach is severable. There are remedies. So if the breach is material, okay, and it is so material that you can consider the contract as a whole as breach, okay, the remedy is you can refuse to proceed further or cancellation and damages. Okay. If it is severable, okay, meaning the breach is not tantamount to the breach of the entire contract, claim for compensation or claim for damages lang. Okay? Yan yung scenario under paragraph 2 of Article 1583. So, in summation, we have the first paragraph, general rule, delivery by installment is not allowed. Exception if both parties agree. Okay? Paragraph 2, okay, if both parties, the buyer and the seller agreed that delivery be made by installments and payment be made separately. Okay? And the situation is the seller makes defective deliveries, the buyer neglects or refused without just cause, or fails to pay for one or more installments. That breach or these three breaches of contract, okay, may either be considered as material or severable. Okay? If the breach is material, okay, meaning you can consider the entire contract as breach, okay, your remedy is to refuse to proceed with the contract plus damages. Okay, but if it is severable, okay, meaning that breach, yung minention ko na tatlong breach ito, okay, does not constitute the breach of the whole contract, then the only remedy for the buyer is to claim for damages or compensation for that portion that is considered as breach. Okay, siguro kung failure to pay one installment, siguro, di ba, that can be considered as severable. Okay, but if more than one, okay, let's say for example, the buyer has not paid for 4 or 5 installments, you can consider the whole contract as materially breached. Okay, so that is Article 1583 with regards to delivery by installment. So we discussed acceptance and delivery under 1582 and delivery by installments under 1583. Okay, 1584, where goods are delivered to the buyer. So meaning the goods are already in the possession of the buyer, which he has not previously examined. So, na-deliver na kay buyer pero hindi niya previously na-examine. He is not deemed to have accepted them unless and until he had the reasonable opportunity for examining them for the purposes of ascertaining whether they are in conformity with the contract. If there is no stipulation to the contrary. Meaning, Ang obligation din ni buyer is not limited to merely accepting the delivery and paying the purchase price. Sinasabi natin under Article 1584 that the buyer has the obligation to examine. Okay? To examine the thing delivered to him. Okay? Why? Because if he fails to examine within a reasonable time, then that is considered as an accepted. Okay? So before niya accept, he must examine it first. Okay? But, sabi dito, he's not deemed to have accepted them unless and until he had a reasonable opportunity for examining them for the purpose of ascertaining whether they are in conformity with the contract. So when we say reasonable opportunity of examining them, it will always depend to the facts and circumstances of the case. Diba? If it's a movable property, like siguro a second-hand cell phone, a 10 to 15 minutes examination is already a reasonable opportunity for you to examine. Diba? If you buy, di ba, pag nasa groceries naman kayo or pag bibili kayo ng mga appliances, you are examining the product first, di ba? Bago nyo bilhin, bago nyo bayaran. Oh, that is examination. Okay? Di ba, pag bumili pa kayo sa ano yun, sa 698 yan, sa Unitap, ayan. Pag mga electronics or something ang binili nyo dyan, you are, after mo ma-examine personally, di ba meron pa sila yung ipapatest mo pa, ayan, kung gumagana yung binili mo, di ba? That is giving you an opportunity whether you are going to push through with the sale transaction or not. That's already the opportunity for you. Para kung defective, o hindi mo bilhin. Diba? That is the point of Article 1584. Okay, when the goods are delivered to the buyer has a right or obligation to examine them. Why? Kapag hindi mo ginawa, let's say for example, dineliver sa'yo, okay na yan. Pag alis nung seller, saka ka nagreklamo. Nung pagka-open mo, saka ka nagreklamo. Okay? This is a delivery in the context of the seller delivering to the buyer. Hindi the seller delivering to the buyer through carrier. Iba yun. We'll discuss that later. Ito, seller to the buyer. Okay? Unless otherwise agreed to the second paragraph, when the seller tenders delivery of goods to the buyer, he is bound on request to afford the buyer a reasonable opportunity of examining the goods for the purpose of ascertaining whether they are in conformity with the contract. Meaning, if the buyer requests that if he may examine the thing delivered, then the seller or the vendor is obliged, sabi dito, di ba? He is bound. He is obliged. He is bound to afford the buyer a reasonable opportunity to examine the goods. Okay, what do you mean by reasonable opportunity? As I have discussed earlier. Okay, so the obligations of the buyer is not limited to acceptance and payment. Okay, it also includes examination. You can interpret this parang as a right, diba? If you are a buyer who is exercising due diligence, then as a buyer you are to exercise your right of examination. Okay? To the third paragraph, okay, where goods are delivered to a carrier by the seller. Yan na. In accordance with an order from or agreement with the buyer, upon the terms that the goods shall not be delivered by the carrier to the buyer until he has paid the price. So parang COD. Whether such terms are indicated by marking the goods with collect on delivery or otherwise, the buyer is not entitled to examine the goods before the payment of the price in the absence of agreement or usage of trade permitting such examination. So what do we mean by the third paragraph of Article 1584? It means that when the goods are delivered by the seller to the buyer through a common carrier, okay, by virtue of a sales agreement or a contract, the buyer is not, take note, the buyer is not entitled to examine the goods before the payment of the price. Kaya siya naka-box. Okay? In the absence of agreement or usage of trade permitting such examination. Meaning, dun sa contract nyo or dun sa agreement nyo with the seller, okay, walang nakalagay dun na you have the right to examine the goods. Okay? Pero kung meron nakalagay doon na pwede mong i-examine, pwede. Okay? Kaya nga, itong mga delivery, yung mga common carriers natin, they are not to open your cargoes or your deliveries. Okay? Hindi nila yan bubuksan. Okay, why? Because to protect the integrity of the thing being delivered. Okay? So, paano pag na-examine mo later on? So, we have a procedure for that. Okay? May discuss natin siya later. Okay, but this is what Article 1584 provides, no? That when the goods are delivered through a common carrier, okay, the buyer is not entitled to examine the goods if it is cash on delivery or collect on delivery. Okay? Kaya i-examine nyo yung pag nag-order kayo ng Lazada, ayan, ng Shopee, examine nyo yung terms and agreements doon sa sale. Okay? Kasi baka check lang kayo. Examine nyo if pwede nyo siyang i-check nyo yung terms and conditions bago kayo magpa-deliver. Okay? Ayan, yung sa 1584. Okay? Pero madami kasing buyer na di ba parang binubuksan nila ata sa harap ng rider. The rider does not know that or the common carrier does not know that. That is a third party individual in the contract. Di ba? Remember, pag nag-order kayo sa Lazada or sa Shopee, ang ka-contract nyo is yung seller dun sa Lazada. Yung seller, hindi yung Lazada. Iba pa yung Lazada, iba pa yung seller, iba pa si Ninja Van, iba pa yung third party na common carrier. Sila, inutusan lang silang i-deliver yan sa inyo. Ang ka-contract nila is si seller. Okay? They had nothing to do with those goods. Ang extent lang ng liability nila dyan is to deliver the goods properly, okay, or safely. Okay, if babasagin man yan, to ensure na walang mabasag, na ma-deliver sa inyo in a proper form. Okay? Kaya kahit pa sabihin mo na kunin nila yan, although meron siguro yung iba na kinukuha nila at kasi napipilitan kasi ang sungit ni buyer, ang sungit nung pinag-deliveran nila, sila nang nag-aayos. But then again, they are not required to do that. Ang ginagawa, I think, is pinapadala yan. Binabalik kung gusto mong ibalik. Okay? Kung hindi mo binayaran, okay lang. Di ba? Cash on delivery naman. Kung ayaw mong bayaran, huwag mong bayaran. Diba? If it's not what you ordered. Okay? Sige. 1585, the buyer is deemed to have accepted the goods. So, when can we say that the buyer has accepted the goods? The buyer is deemed to have accepted the goods when he intimates to the seller that he has accepted them. Diba? Very obvious. Diba? Sinabi niya, okay na to. Sige, okay na. Tinatanggap ko na. Or, sige, okay na. Akin na to. Bayaran ko na. Yan, he intimates to the seller that he has accepted them. When the goods have been delivered to him and he does any act in relation to them which is inconsistent with the ownership of the seller. Anong ibig sabihin niyan? So yung una, when he intimates to the seller that he has accepted them, whether expressly or verbal, ayan. Pero when he does any act inconsistent with the ownership of the seller, meaning what? What are acts inconsistent with the ownership of the seller? Simple lang yan. When the buyer does acts of ownership over the property. Diba? Kapag gumawa siya ng acts na only the owner can do, that means the buyer is accepting the goods. Okay? Pag bumili ka ng, pag may binibentahan ka ng pagkain na lang para madali, ng tinapay, for example, diba? Gustong bilhin ng kaibigan mo, kinuha. Diba? Hindi pa tinanong yung presyo, kinagatan na, kinainan na. Okay, he must pay for it because he does acts inconsistent with the ownership of the seller. Hindi sa kanya yun, kinain niya. O that is inconsistent with the ownership of the seller. Kakainin mo pag sayo. Okay, dali, di ba? Okay, ganun. Ganun yung second circumstance. So una, intimates to the seller that he has accepted them. When he does any act in relation to them which is inconsistent with the ownership of the seller. Or, third, after the lapse of a reasonable time, he retains the goods without intimating to the seller that he has rejected them. When we say reasonable time, and again, sabi ko, depends on the facts and circumstances of the case. What is a reasonable time will depend on the facts and circumstances of the case. Basta, he retains them without informing the seller na ayaw niya or na hindi niya tinatanggap. He retains them. That is deemed accepted. Okay? So kapag may na-deliver sa'yo, okay, and hindi mo signify sa seller na ayaw mo, pero nasa'yo, 7 days, 2 weeks nang lumipas, wala ka pa rin kino-communicate kay seller, okay, pero nasa'yo yung goods, that can be considered as deemed accepted. Kasi kung ayaw mo yan, syempre ayaw mo rin bayaran yan, ibabalik mo yan. Isi-signify mo kay seller na ayoko itong binenta mo. Okay, babalik ko na. Hindi ko naman siya na-open. Ganyan. Ganyan. But if tumagal sa'yo for an unreasonable period of time, that is deemed accepted. Why? Because ba't tatagal sa'yo kung hindi mo siya, kung i-reject mo din naman? Diba? What's your justification for that? Okay, and under the law, the presumption is that is deemed accepted. Okay. And kapag ganyan ang meron kasing ibig sabihin itong mga to sa evidence. Yan. Basta masabi lang ni seller na nasa'yo yan for 2 weeks, mag-a-apply na tong Article 1585 eh. Ano ibig sabihin nun? Deemed accepted siya. Therefore, ikaw na buyer, you are going to provide an answer. Bakit hindi siya deemed accepted? Diba? Pag nasa court na kayo. Yan. Pag nagkaso-kaso na. Anong rason mo? Ba't tatagal sa yung product for 2 weeks? Unless, justifiable yung reason. It depends on the case. Okay? Article 1586, in the absence of express or implied agreement of the parties, so without the agreement, acceptance of the goods by the buyer shall not discharge the seller from liability in damages or other legal remedy for breach of any promise or warranty in the contract of sale. So the first sentence of Article 1586, okay, implies or signifies that the acceptance of goods will not discharge the vendor for his liabilities in case of damages or in case there is a breach of warranty or breach of contract. Okay? Hindi ibig sabihin na in-accept ni buyer, wala nang liability si vendor. Take note, di ba, ang warranty may be expressed, may be implied. Okay? Whether meron or wala. If liable si buyer, ay si seller for warranty against eviction, which is an implied warranty, kahit walang agreement, or warranty against hidden defects, which is also an implied warranty, kahit walang agreement. Kapag in-accept yan ni buyer, hindi ibig sabihin na wala na yung warranty. Meron pa rin. Okay? But if after acceptance of the goods, the buyer fails to give notice to the seller of the breach in any promise of warranty within a reasonable time after the buyer knows or ought to know of such breach, the seller shall not be liable thereof. Diba? Diba? Remember, during our previous discussions, we have periods with regards to warranties, with regards to filing a case for redhibitory actions, diba? 40 days. Ayan. So that could be considered as reasonable time. Let's say, for example, in a sale of an animal, diba? The period to file redhibitory action is 40 days. Okay? If meron kang claim for redhibitory action, okay, if meron kang claim for redhibitory action, and hindi mo siya na-file within 40 days, okay, isa lang ibig sabihin niya that your action has already prescribed. Meaning, you may have an action, meron kang case, meron kang claim, pwede kang mag-claim, but it has prescribed. Meaning, hindi mo na-give, hindi mo na bigyan, hindi mo siya na-file in time sa court. But that is with regards to prescription. Itong second phrase or second sentence kasi ng Article 1586, meaning failing to give notice to the seller within a reasonable time for the breach in any promise of warranty. Meaning from the time that you had knowledge, okay, or you ought to know of that breach, okay, dapat na-notify mo na agad si seller. What the law prevents is yung sinasabi nating afterthought. Para lang may maklaim ka. Diba? Maghahabol ka. but that may not, the seller may no longer be liable if if you fail to give notice to the seller within a reasonable time. Okay, that's Article 1586. Okay, Article 1587, unless otherwise agreed, so exception again, inuna, where goods are delivered to the buyer and he refuses to accept them, having the right so to do, he is not bound to return them to the seller. But it is sufficient if he notifies the seller that he refuses to accept them. Okay? What does, you don't notice the first sentence. What does the first sentence of Article 1587 means? Of course, it speaks of a general rule and an exception. The general rule, if goods are delivered to the buyer and the buyer refuses them, having the right to do so. Meaning, justified yung pag-refuse ni buyer dun sa delivery. Okay? Ang sabi dito, the buyer is not bound to return them to the seller. Okay? But it is sufficient, ang gagawin niya lang is to notify the seller that he refuses to accept them. Okay? Meaning, if you have a ground for refusing to accept the delivery, then you are not bound to return them to the seller. Why? Because the seller failed to deliver what he promised, kaya nga binabalik mo eh. Eh bakit? Why are you bound to return them? No, hindi ka bound na ibalik yan. Siguro ang under the law, ang sufficient na gagawin mo is to notify. Yun lang ang gagawin mo. Okay na yun. Basta i-notify mo, okay na yun. You are not bound to return them. But take note, that is the general rule. There will always be an exception, ang sabi, unless otherwise agreed. Kaya nga sabi ko sa inyo, balikan niyo yung terms and conditions ng Shopee, Lazada, Zalora. Okay? Kung ano yung agreement nyo doon. Okay, why? Baka yan nakalagay dyan na kung gusto mong ibalik or kung ayaw mong tanggapin yung delivery, ikaw mismo na buyer ang magde-deliver. Baka yun yung nakalagay doon. Kaya yun yung gagawin nyo. Hindi pa naman kasi ako nag-return ng item na dineliver. Kaya hindi pa ako aware kung paano yung procedure dyan sa pagbalik. But definitely check the terms and conditions of your sales agreement. Okay, kasi ang daming provisions na diniscuss natin kanina, including this one, na lagi niyang sinasabi, unless otherwise agreed. Okay? And yan, kapag nakalagay yan sa contract, yan ang mangyayari. So kahit sana, under the law, sabi ni attorney, hindi kami bound to return them. That is under the law. And the law also states na unless otherwise agreed. Okay, tama ka. You are not bound to return them. Pero tandaan mo, chinek mo yung tick box ng terms and conditions na nag-agree ka fully and na you understand fully the terms and conditions. O hindi mo na ngayon pwedeng sabihin na ayaw mong i-return yan. You are now obliged to return them if yun ang nakalagay sa provisions ng sales agreement nyo o sa terms and conditions ng Lazada or ng Shopee. Diba? So, kaya lagi natin sinasabi, beware. Diba? Before you sign anything, read them. Read them thoroughly. Read them slowly if medyo nalilito kayo sa terminologies or dun sa masyadong madaming binibigay in terms and conditions, you read them. Okay, especially if you are now hindi pa kayo graduating, no? Kung mag-graduate na kayo later on or anything, before you sign anything, you read what you are signing. We apply that now. Okay? Before you agree to anything online or sa mga apps, before nyo i-tick yung checkbox, okay, you read them. Why? Because baka may mga provisions na ganyan na you are agreeing. Later on, uh, you cannot refuse to do. Kasi you are bound by your agreement. Kaya you be careful. Diba? Buyer beware. Okay? If, sabi sa second sentence, if he voluntarily constitutes himself as a depositary thereof, he shall be liable as a depositary, of course. Meaning, ayaw mo ng goods. You have right to refuse it or justified yung pag-refuse mo. Okay? But then, naiwan sa'yo yung goods and kinip mo sa'yo yung goods. Okay? Or yung thing na dineliver. Okay? You may voluntarily constitute yourself as a depositary. Meaning, you have the obligation to keep the thing safe. Okay? Until ma-deliver or may balik kay seller. Okay, but being a depositary, of course, meron din yung bayad. Siyempre naman. Kaya, and if he voluntarily constitutes himself as a depositary thereof. Diba? Kung iniwan sa'yo, alagaan mo, ikipanayon it, may bayad dyan usually. Okay, kasi, may bayad kasi you may be liable as such. May obligation ka lang na bantayan yun, safe keep yun. Meron din in turn, of course, na payment si seller sa'yo. If that will be later on your agreement. Okay. That later on will be your agreement. But if hindi yan ang agreement siya later on, then walang ganyan na mangyayari. Okay, because we are under the civil law. Article 1588, if there is no stipulation as specified in the first paragraph of Article 1523, delivery by the common carrier, when the buyer's refusal to accept the goods is without just cause. Tandaan nyo kanina, 1587, ang sabi natin, with or having the right so to do. Meron siyang right or meron siyang just cause to refuse it. Ito, he has no just cause to refuse it. Anong mangyayari? The title thereto passes to the buyer from the moment they are placed at his disposal. Meaning, ayaw mong tanggapin. Pero wala kang rason kung bakit ayaw mong tanggapin. Okay? Ang sinabi ng batas, the title passes to the buyer the moment that it is placed under his disposal. The moment that it is placed or it is delivered to you. Okay, you are now considered as the owner. Okay, take note that the refusal here is without just cause. Okay, unlike 1587, na you are not bound to return them, kahit iwan yan sa'yo. Okay, basta hindi mo i-accept, you are not bound to return them. Okay, hindi ka rin naman automatic na maging depositary. Kasi ang sabi dyan, if he voluntarily constitutes himself. So there must be a subsequent agreement for depositary. Okay? Basta with just cause, yung pag-refuse mo. So, comparing the two provisions, I hope you can fully understand a case, both cases. The first one is refusal with the right to do so or with the just cause, and refusal without just cause. Okay? 1589, the vendee shall, this one I think I know, medyo bahasa ko dito kasi. The vendee shall owe interest for the period between the delivery of the thing and the payment of the price in the following cases, in the following three cases. So, sabi niya, the vendee shall owe interest. So, liable si vendee for interest in these three cases. If there is a stipulation. If there is a stipulation na merong delay from the time of delivery until the time na binayaran mo, then liable ka for interest. Okay? If the thing sold and delivered produce fruits or income, during this period, di ba, na-deliver sa'yo, tapos hindi mo kaagad nabayaran. During this period, may fruits or income na na-earn yung property, you are liable for the interest. Okay? Should he be in default from the time of judicial or extrajudicial demand for the payment price? Okay? Liable ka for interest. So, in summation, going back to Article 1589 describes the instances wherein you are going, the buyer is liable for interest. When the buyer is liable for interest between the period of delivery and payment of the purchase price. So dito na period, liable ka for interest kapag merong stipulation. Okay? Take note, under our laws, hindi siya basta-basta na kahit walang stipulation. So even if there is no stipulation, there is what we call a legal rate for interest. Diba? In terms of monetary obligations, there are legal rate for interest which is equal to, I think, 6%, annually. So kahit walang stipulation, liable ka for interest as long as that is a monetary obligation, as long as there is delay, there is demand. So, under the first circumstance, there should be a demand. Dapat merong demand. And demand could be made judicially, number one, or extrajudicially. When we say judicially, we relate this to number 3 na para as one yung discussion, you demand through court. Paano ka mag-demand through court? Kasuhan mo. Diba? That is demand in itself, although it's done judicially. Okay? Demand could also be made extrajudicially, meaning you made the demand out of court. Okay? Meaning, pumunta ka sa abogado mo, nagpagawa ka ng letter of demand, pinadala mo. Yun, letter of demand. Okay? Pwede ring verbal, but the problem with verbal demands is later on, pag nag-file ka ng case, you don't have proof that you have made the demand orally. That's why what they do, and what I advise my clients to do, is to put everything in writing. Kahit sila pang mag-demand, you put everything in writing. Okay? Kasi kung ako ang gumawa ng demand, the charge may range from 500 to 1,000. Oh. At least yan, they can do the demand themselves. Okay? So, sa first circumstance, sabi ng civil code, it must be stipulated, but take note, we have a law with regards to monetary obligations providing for a legal interest rates for monetary obligations. Okay, that even without stipulation, you can claim interest. Okay, and by doing so, before you can claim for interest, you must first demand. Okay, sabi nga, sa obligations and contracts nyo, if maalala nyo pa, di ba? No demand, no delay. Meaning, kung hindi ka nag-demand, di parang hinahayaan mo na hindi siya magbayad. Di ba? You are sleeping on your rights. Di ba? But if you demand, meaning you are exercising your rights, there you can establish na merong delay. And there, since merong delay, you can claim for interest. Okay? Second one, should the thing sold and delivered produce fruits or income? This one, you don't need demand. Why? Because the proofs themselves are the fruits or the income that has been generated by the property or by the thing during this period. Yun yung basis mo for interest. Okay? For case number 3, of course, demand is needed. Bakit? Should he be in default? Itong default, yan yung delay. No demand, no delay, or no default. Ito yung delay na sinasabi natin. Should he be in default or should he be in delay? But, hindi lang words yan. You should establish that the buyer is already in delay. And how do you establish that the buyer is already in delay or in default? You make a demand, whether judicial or extrajudicial, as I have discussed kanina, diba? For the payment of the price. That is Article 1589. Let's proceed to Article 1590. Should the vendee be disturbed? Yeah, may disturbance in the possession or ownership. So, the disturbance could either be in the possession, meaning the right to enjoy the thing, or to the ownership of the thing itself, or should they have reasonable grounds to fear such disturbance? So either na-disturb siya in his possession, or ownership, or he has reasonable grounds to fear a disturbance by what? By a vindicatory action or a foreclosure of mortgage. He may suspend the payment of the price until the vendor has caused the disturbance or danger to cease. Okay. Diyan muna. Huwag muna tayong pumunta sa unless. So, balikan natin. If there is a disturbance experienced by the vendee, or even if there is no disturbance, if there is a reasonable ground to fear a disturbance by a vindicatory action or foreclosure of mortgage, these are legal actions. Okay? Para ma-clear kayo. The vendee may suspend the payment of the purchase price until the seller has caused the cease or napigilan ni seller yung disturbance or danger. Okay? Doon niya lang pwedeng i-continue magbayad. Unless the latter, meaning the vendor, gives security for the return of the price in a proper case, or it has been stipulated that notwithstanding any such contingency, the vendee shall be bound to make the payment. So, una muna, general rule. In the cases I have mentioned, the buyer may suspend the purchase price. Diba yung in-explain ko kanina, itong nasa taas, itong a disturbance, reasonable grounds, yan. Yes, the right to suspend. Except if the vendor gives security for the return of the price. Okay? Meaning nagbigay ng assurance or ng guarantee or ng security si vendor that the price will be returned if matuloy man yung disturbance na yan or yung legal actions na yan. Okay? Or merong stipulation sa contract. Ayan na naman tayo sa stipulation. Very powerful ang stipulation because it can override the law. Kasi ang sabi niya dito, it has been stipulated that kahit pa merong contingency, notwithstanding any contingency, if my stipulation na the vendee shall be bound to make the payment. Meaning, doon sa contract may nakalagay, notwithstanding any contingency, the vendee shall be bound to make the payment. Yan. Hindi pwedeng exercise ni vendee yung right to suspend the payment. Okay? Why? Una, because mayroong binigay na security na si vendor. Pangalawa, because there is a stipulation to the contrary. Okay? Tanong, let's say for example, in a sale of a property, lupa, sabihin mo na, between the buyer and the seller, then later on, inoccupy ni buyer, merong nag-trespass dun sa lupa. Can that be considered as a disturbance in the possession or ownership, or can that be considered as a reasonable ground to fear such disturbance? The answer is no. Okay? Ang disturbance or ang disturbance na tinutukoy natin dito is a vindicatory action, a case filed in court, or a foreclosure of mortgage. A trespass to property is not a legal action. It is a trespass. Actually, that is an act against the law. O, diba? Pwede mo silang filean kung may nag-trespass sa property mo. But that act of trespassing is not a legal action that you can invoke Article 1590. So pag may nag-trespass, you cannot invoke Article 1590. May nag-trespass dun sa sa property ko. Ayoko nang bayaran. Suspend ko na according to Article 1590. Sabi sa amin ni attorney, no. Okay, because trespassing is not what is referred to by law. Ito lang sinasabi ng law. Limited tayo dyan. Vindicatory action and foreclosure of mortgage. Okay, kasi nga, any property naman na trespass, di ba? That is not a disturbance by a legal action. Okay? So yan yung 1590. Take note of that, okay? 1591. Should the vendor have reasonable grounds to fear? Ito naman si vendor naman. Kanina, si Vendee. Ito naman si vendor. Should the vendor have reasonable grounds to fear? Reasonable grounds to fear the loss of an immovable property and, take note, it states here, and its price. He may immediately sue. Pwede siyang mag-file kaagad ng case for rescission of the same. What does paragraph 1 of Article 1591 states? Kapag si vendor, mayroon siyang reasonable grounds to fear na pwedeng mawala. take note, immovable property ito yung bahay or lupa na binenta niya and yung price, he may immediately sue for rescission. Bakit may ganito sa batas? Nabenta niya naman na. Okay. Why? Because there could be instances wherein the buyer is already squandering the price. Meaning, let's say for example, since the property involved here is an immovable property, kapag immovable, land or bahay or house and land, di ba? Meaning, and usually ang transaction niyan is installment. Hindi naman yan one time babayaran mo yung 10 million, one time babayaran mo yung 20 million, di ba? Unless sobrang yaman mo. Usually, these things, these immovable properties are bought installment on an installment basis. And because of that, the buyer is your debtor. Essentially, the buyer is your debtor. The buyer is obliged to make monthly installments to you. Okay? There are instances wherein siyempre, hindi lang ikaw ang pinagkakautangan ni buyer. Meron din siyang other creditors. Yan. Diba? Okay? Let's say, for example, hindi siya nakabayad sa utang niya kay creditor number 2. Creditor number 2 filed a case in court against B. Since that is the case, there is a tendency na malalaman yan ni seller, ni vendor. Kapag nalaman niya later on natalo si B dun sa kaso kay C, okay? And ang judgment is i-levy or i-attach yung cash niya sa banks. Titignan din lahat ng properties niya. There is a tendency na mawala ngayon yung sinasabi nating immovable property tsaka yung price. Okay? Why? Because there's already a judgment in court na talo si B kay C. Pwedeng i-levy or i-attach, meaning pwedeng kunin lahat ng properties niya para mabayaran yung utang niya sa mga creditors niya. Pwedeng kunin yan kapag mayroong judgment ng court. Therefore, that is already enough ground for the vendor to fear na mawala yung property niya, yung property na nabenta niya. Why? Because pati yung price mawawala. Meaning, hindi siya mabayaran. If that happens, he can immediately ask for rescission. Yan yung Article 1591. Okay? Should such ground not exist, the provisions of Article 1191 shall be observed in case of loss, deterioration, or improvement. Ito yung article, yung loss, deterioration, or improvement. Article 1592, in the sale of immovable property, take note, immovable na naman. So we are referring to land or buildings or land and buildings. Even though it may have been stipulated that upon failure to pay the price at the time agreed upon, the rescission of the contract shall of right take place. Okay? Ang sabi niya dito, masyadong mahaba para mawala tayo sa thought. Ang sabi ng phrase na yan, okay, kahit pa merong stipulation na kapag the vendee fails to pay the price, rescission shall take place. Yan daw. Kapag merong stipulation na ganyan, the vendee may pay. So, pwede pa rin magbayad si vendee. Even after the expiration of the period, as long as no demand for rescission of the contract has been made upon him either judicially or by a notarial act. After the demand, the court may not grant him a new term. Okay? So, this means that in the sale of an immovable property wherein there has been a stipulation that within a period of time, the buyer fails to pay the purchase price, rescission shall take place. The law states that the vendee may still pay even after the expiration of the period to pay, as long as the only condition is there is no demand yet filed. Okay? Or the demand given by the vendor. Take note of the type of demand. The demand must be judicially, or by a notarial act. Okay? So, hindi siya basta-basta extrajudicial demand. It must be a notarial act, meaning pag sinabi nating notarial act, it is a demand executed under oath. It is under oath. Meaning that the vendor is seriously demanding for the payment. Okay? Because he is executing a demand under oath. Kapag under oath kasi, the implication of executing any statement under oath, you may be liable for perjury. Kapag hindi totoo yung nilagay mo dyan sa statements mo, you may be liable for perjury. Why? Because that should be executed under oath. You are expected to say the truth. Okay? To state only the truth. Okay? So, pwede pang magbayad as long as there is no demand. Okay? Kaya ang sabi ko kanina, under obligations and contracts, no demand, no delay, or default. This already, actually alam nyo na ito di ba? This already gives you an idea, okay, that in order to put the vendee or kahit siguro yung debtor mo, yung nagpautang sa'yo, in default, okay, para maging in default yung nagkautang sa'yo or si vendee, you must give a demand. Okay, whether judicial yan or extrajudicial or through a notarial act. Okay, why? What is the importance of giving a demand? So that the interest period will run. You can claim for damages, you can claim for interest from the time that you executed a demand, meaning from the time that you're exercising your right. So bale, kung gano'n ang nangyari or ang mangyayari, hindi lang liable si vendee for the price itself or yung nagkautang sa'yo for his loan itself. Liable din siya for interest. Liable din siya for possible damages. Okay? Kaya ginagawa yung demand na yan. That's the importance of a demand. And cases are sometimes dismissed because of lack of demand. Siguro nakakaligtaan din ng abogado na, kailangan pala mag-demand muna. Okay. Take note, kapag kaso yan na civil, meaning itong mga civil code ng mga provisions, as long as hindi yan crime, okay, hindi kaagad sa korte. Hindi automatic sa korte. Saan yan dadaan? Sa barangay. Barangay muna. Why? Because kasi kapag inalaw mo na kaagad diretso sa korte, imagine yung court punong-puno na ng kaso. Actually, yan yung problem ng court, diba? Yung declogging of cases sa dami ng kaso. Okay, that's why required sila na mag-undergo ng barangay para masettle na nila sa barangay. Okay? Ganyan ang civil case. Civil. The last paragraph for obligations of the vendee, if kanina yung sabi natin with respect to immovable property, this one naman with respect to movable property. So, personal property, anything that you can transfer, okay, or bring with you, movable, from the word itself. The rescission of the sale shall right take place in the interest of the vendor. So the rescission will take place in the interest of the vendor if the vendee, upon the expiration of the period fixed for the delivery of the thing, should not have appeared to receive it, or having appeared, he should not have tendered the price at the same time. So, under this article, okay, hindi pa nade-deliver yung property. There is no delivery yet. Why? Because sabi dito, upon the expiration of the period fixed for the delivery of the thing, ibig sabihin, ide-deliver mo pa lang yung property. Wala pa kay buyer. Okay? Ide-deliver pa lang ni seller yung property. Okay? Pero, hindi nag-appear si buyer to receive it. Okay? Or, kahit pa nag-appear si buyer, the buyer did not tender the price at the same time unless a longer period has been stipulated for its payment. Ang gagawin ni seller, okay, kapag ganito ang nangyari, he may, at his instance, okay, rescind the contract. This is actually, simple lang ito. Diba? I-deliver na sa'yo ni seller yung thing na binili mo. Okay? Pero, hindi ka sumipot. Kunwari, meron kayong place of delivery. Wala ka. Okay? Or, meron ka pero hindi mo naman binayaran. E di, cancel ko na lang. Hindi mo pala babayaran. Diba? Unless, dito sa number 2, unless, meron kayong stipulation na naman na i-deliver ko sa iyo ngayon, bayaran mo na lang ako, babayaran mo ako after 2 weeks or on a specified date. Ayan, unless a longer period has been stipulated for each payment. So, in summation, okay, in a sale of movable property, wherein the seller, okay, is about to deliver the property or upon the expiration of the period fixed for the delivery of the thing, the buyer did not appear to receive the property, or the buyer having appeared did not tender the payment of the price at the same time of delivery, the seller can rescind at this instance the contract of sale. The exception is only with regards to the second instance wherein the buyer has not tendered payment if there is a stipulation providing for a longer period for the payment of the price. Diba? Kung ikaw na seller, okay, nakipag-agree ka dun sa buyer na mag-meet tayo sa Mall of the Valley, sa MOV, ng 2 p.m. Okay, idadala ko yung cellphone na sinabi mo na gusto mong bilhin. If hindi ka nag-appear doon, pwedeng i-cancel ko na. Hindi ka sumipot eh. 'Di ba? Or sumipot nga siya sa Mall of the Valley 2 p.m. pero hindi naman siya nagbigay ng payment ng purchase price. Ang usapan nyo is bayaran niya pag nakita niya na or na-examine niya na yung property. Pero hindi niya binayaran, you can cancel, di ba? Very ordinary, kumbaga. Okay, but it is in the law so that the parties may be protected. So that is obligations of the vendee. Okay? Any questions? Going once? Going twice? Wala? Sige. So that ends our topic for obligations of the vendor. So next week, as I may not meet you guys for this week, we'll proceed with actions for breach of contract and extinguishment of sale. Okay, and also expect for a case study I will upload later this evening to be submitted Wednesday? Wednesday next week. Okay? So if no questions, 7:30. Oh, it's saktong 7:30. Let's call it a night. Good night, everyone. Good night.